provision for divorce by mutual consent should be included in the Indian Divorce Act is a matter of legislative policy. The courts cannot extend or enlarge legislative policy by adding a provision to the statute which was never enacted there. Therefore, I started by saying that marriage is a socio-legal institution. Its recognition is a matter of legislative policy. Then, my lord, Keshavanand Bharti, my lord, kindly allow me to read, my lord. This would guide, my lord, us throughout, my lord, the hearing of this case. How we construe the constitution in the context of the marriage being given the recognition, my lord. Underlined portion. It cannot be denied that provisions of the constitution of other countries are designed for the political, social, and economic outlook of the people of those countries for whom they have been framed. The seed of the constitution is sown in a particular soil, and it is the nature and the quality of the soil and the climatic conditions prevalent there which will ensure its growth and determine the benefits which it confers on its people. We cannot plant the same seed in a different climate and in a different soil and expect the same growth and the same benefit therefrom. Law varies according to the requirements of time and place. Justice thus becomes a relative concept varying from society to society according to the social milieu and economic conditions prevailing therein. The problems which confront those courts in the background of the state of the society, the social and economic setup, the requirements of people with a totally different ethics, philosophy, temperament, and outlook, differentiate them from the problems and outlook which confront the courts in this country. It is not a case of shutting out light where they could profitably enlighten and benefit us. The concern is rather to safeguard against the possibility of being blinded by it. Lord, this takes us to, my lord, the theory that ultimately societal acceptance is one of the considerations for recognition of any union. And that can be tested only in the legislature. And, my lord, there is a beautiful passage I'll read, my lord, from the American Supreme Court, which says that any recognition by the court does more harm to LGBTQ plus community than help them. Because then you are forcing something which should have come from within. That's the logic, my lord, of the Honorable Supreme Court. Now, my lord, A.K. Roy, my lord, 5-judge bench. I'll read, my lord, the highlighted part. But we cannot transplant in the Indian context and conditions principles which took birth in other soils without a careful examination of their relevance to the interpretation of our constitution. No two constitutions are alike, for it is not mere words that make a constitution. It is the history of the people which lends color and meaning to its constitution. Lord, we cannot forget the historical background and the anthropological background, my lord, which eventually resulted into creation of an institution called marriage across faiths, across religion. Now, my lord, your lordships have seen, but my lord, Justice Cardozo, my lord, a little hard-hitting, my lord, word, but my lord, it really, my lord, I would wish, my lord, to place it. When they say that all we want is a recognition, all we want is the confirmation of our right. The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his own idea of beauty. I'm sorry.
It's the nature of the judicial process.
That's correct. That's correct, my lord. But, my lord, only a few words I wanted to highlight, my lords. Not the first part, which is slightly, my lord, a little more harsher, my lord. But thereafter, he is to draw his inspiration from the consecrated principles, and this is important. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. That's what, my lord, I am driving at. the class with which, my lord, your lordships are dealing is an unidentifiable class. They have their class-specific problems. It would be completely, my lord, a vague declaration, if at all it is to be made, without, my lord, conceiving the problems they would be creating, my lord. The mere declaration would continue. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinate to the primordial necessity of order in the social life.
Primordial.
I'm sorry, primordial.
I think our own Justice Patanjali Shastri has put it all in that one short paragraph in V.G. Rao. Everything that is on reasonableness and
Yes,
what is the
yes.
role of the court.
Yes. Lord, kindly come to, my lord, para 74, para 73, 74, and 75. This would be relevant, my lord, for my purpose, because I'm going to, my lord, rely upon Obergefell, Windsor, and, my lord, their dissent. A beautiful dissent, because for us, both, my lord, majority, minority, both are having persuasive value. It was a thin majority of 5 versus 4. But numerically, yes, majority, my lord. Dissent is a dissent, but, my lord, which would really assist your lordships. Now, your lordships may kindly see the landmark dissent of Justice Oliver Holmes in Lochner versus New York, which criticized the majority of the court for becoming a super legislature by inventing a liberty of contract theory, thereby enforcing its particular laissez-faire economic philosophy, is still remembered as a remarkable piece of judicial foresight. My lord, then I have cited, my lord, this judgment with a reason. My lord, please allow me to cite Daybright lighting. I'll just read, my lord, the highlighted part.
Yes.
Our recent decisions make plain that we do not sit as a super legislature to weigh the wisdom of legislation, nor to decide whether the policy which it expresses offends the public welfare. Lord, 75, and before I, my lord, read that, my lord, I would like to, my lord, just paraphrase it. Specifically, the dissent of Justice Holmes came to be fully accepted in Ferguson versus Krupa and continues to be the law of America till date. Interestingly, the dissent in both same-sex marriage cases in the American Supreme Court in Obergefell versus Hodge and United States versus Windsor blame the majority for committing the same mistake it did in Lochner suit. I'll read, my lord, and thereafter, what happened after, my lord, this Obergefell judgment in Dobbs. This is doubted. Now, your lordships may, my lord, kindly directly come to, my lord. My lord, rest of the judgments are same, that your lordships would not, my lord, as a prudence and as a policy, substitute the wisdom of the legislature. But, my lord, kindly come to page 23, that is, my lord, 27 PDF. Only the highlighted part. Your lordship gets, my lord Justice Narsingh. Page 23, PDF 27, my lord Justice Butt and Justice Call.
Yes.
Read the highlighted part. The power of the court to legislate is strictly limited. Judges ought to remember that their office is just decree and not just dere, to interpret law and not to make law or give law. Chief Justice Chandrchud, my lord, this can be, my lord, said now, my lord, that's my request. Chief Justice Chandrchud can say this, my lord, in the present judgment, my lord, on the lighter side, my lord. Chief Justice Chandrachud, speaking for a constitution bench in Gurbakh Singh CBI versus State of Punjab, has clearly pointed out the limited powers of the court to make laws in construing the provisions of the statutes. The learned Chief Justice has observed the true question is whether by a process of construction, the amplitude of judicial discretion which is given to the High Court and the Court of Session to impose such conditions as they may think fit while granting anticipatory bail should be cut down by reading into the statute conditions which are not to be found therein. Our answer clearly and emphatically is in the negative. Nothing more can be read into the statute. Then, my lord, again the learned Chief Justice warned, judges have to decide cases as they come before them, mindful of the need to keep passions and prejudices out of their decisions. And it will be strange if, by employing judicial artifices and techniques, we cut down the discretion so wisely conferred upon the courts by devising a formula which will confine the power to grant anticipatory bail within a straitjacket. Therefore, even if we were to frame a code for granting of anticipatory bail, which really is the business of the legislature, it can at best furnish broad guidelines and cannot compel blind adherence. The court, by its very nature, are most ill-suited to undertake the task of legislating. There is no machinery for the court to ascertain the conditions of the people and their requirements and to make laws that would be most appropriate. Further, two judges may think that a particular law would be desirable to meet the requirements, whereas another two judges may most profoundly differ from the conclusions arrived at by two judges. Conscious of these handicaps, the law requires that even an amendment of the Supreme Court rules, which govern the procedure to be adopted by it for regulating its work, can only be effected by the whole court sitting and deciding. Lord, the court puts a word of caution that though, my lord, one of the finest, my lord, intellectual brains of the country would be deciding this, but that would not reflect the will of the people. Then, your lordships, my lord, kindly come to page, my lord, I'll just read, my lord, at page 24, that is 29 foot. My lord, it's a constitution bench judgment and only the highlighted part at page 29, my lord. 25, my lord, PDF 29. The court also needs to be mindful that a legislation does not become unconstitutional merely because there is another view or because another method may be considered to be as good or even more effective, like any issue of social or economic policy. It is well settled that the courts do not substitute their views on what the policy is. But my respectful submission is policy throughout all legislations, including Special Marriage Act and Hindu Marriage Act, is recognition of marriage as a socio-legal institution between heterosexual couples. That policy can be reviewed, reconsidered, and redecided by the Parliament, having, my lord, after having wider consultations and, my lord, after gathering all the facts, gathering all possible scenarios which need, my lord, to be regulated.